Yes, counsel.
May it please the court. The danger here, and I hope you read the language in the brief from Powell to Gideon that speaks to the dangers of asking one unlearned in the law and unwilling to go pro se to represent themselves, the danger that comes from forcing that person to defend themselves in court or to act as their counsel in court. And that's the problem. In both Mr. Feichel's case and in Mrs. Porter's case, more could have been done to show that they were indigent. The problem is that they were left on their own, and as you read those transcripts in both of these cases, you're going to see that it doesn't look like they knew what they were doing. To go out and collect affidavits and
But look, even if they have the most experienced counsel, you can't get around. She owned property, didn't she?
Well, what we're talking, yes, with respect to the property, and that, if you want to, I'm happy to jump right into.
And they were getting Social Security and other sources. So.
Yes. So in this case, the first question is her income that she received from Social Security, which is not much. In the end, even the judge says that because of household budgets, money is tight in this home. And then the court went ahead and put a figure of $5,000 to the court. Now, the court did say that if she couldn't procure an attorney, to come back, but...
Well, she had Social Security, and her husband had income as well.
Yes, her husband had income as well.
And they had they had this property with no mortgage on it.
He has the property with no mortgage on it.
But it's her husband.
It is her husband. And again, the question goes back to whether she has access to that. Also, with respect to property...
Is this different than a situation where it's a child, not a child, a child over the age of 21? I mean, is the spousal relationship create greater access than, say, a 21-year-old child who wants his parents to pay? Well,
again, the question is, so, for example, it doesn't appear that she's a signer on the bank account dealing with the property. They do have a joint checking account, but there's not a lot of there's not a great deal of funds that are in that joint checking account.
She recently had a bankruptcy, I believe. So,
yes?
Talking about potentially getting a loan on property that.
Yeah. Again, the question is whether they have access.
Whether she could do it.
Yeah. And so, with respect to property, again, the question, as I argue, is whether.
Are you suggesting that we could have a scenario where you'd have a couple, a married couple, and one of them could say, well, I have all the assets, and I'm not going to make them available to my spouse, and therefore they are indigent?
Yes.
So back to I remind you of Judge Spina's question was at one point, the best thing a parent can do for their kid to say, go sleep on the fire escape. Maybe the best thing a spouse can do is say, we'll put all of our assets in one person's name, and if the other spouse is involved in the courts, we just say that stuff is not available. Is that what if you prevail, that would be the rule?
All I'm saying is that it has to be shown that spouse has access. Again, would a person have greater access to their spouse's property after a year of marriage or after 20 years of marriage? Is it the day you get married that all assets, whether you're a signer on an account or not, become accessible?
You don't look at all to the question whether the spouse has some obligation to his spouse. I mean, if they were getting divorced, all of this would be available to her, right? To split?
Yes.
Do we need to ask what a probate court judge would typically do in these circumstances if there were a petition for support?
No, I don't think you would. I think the rule shows, and it's a question of whether they have access to those funds.
Well, you can get access to the funds by going to the probate court.
Yeah, and that's available if the party so chooses. I'm not saying that they're barred from doing that. They certainly can.
let's go back to the property, particularly the property that has no mortgage, that
So-
I take it is the husband's property. So-
Husband's property, and the question is again, dealing with access. And when we're dealing with property, my argument is that it has to be readily liquidatable, and that means fairly quickly. I mean, you either have to sell it quickly in a short period of time, or you have to be able to obtain a debt on the property.
And does your argument turn on the definition of available assets?
Well, yeah, that's one of the you know.
Let me just find, where's the section on the definitions? Available funds, a party's liquid assets and disposable net income. Liquid assets and disposable net income of this party's spouse. Okay. I don't, so is it your view that property itself is simply not a liquid asset? It talks about liquid assets and disposable net monthly income. Those seem to be the two
Right.
pieces here.
Well, again, first it's whether she has access to the property. We've gone over that. But yeah, no, property is not readily liquidatable, not in most circumstances.
There's something preposterous about that, though. I mean, somebody could own 100,000 acres of land. Somebody could own 50 antique cars, each of which were worth $50,000, and have $100 in his wallet and his bank account. And they couldn't be the court couldn't take into consideration all those cars and all that land?
I don't think what they're talking about is someone who's asset rich and
Cash
poor.
poor.
What we're talking about is how fast can you have, or how fast can you convert that property into cash, either by selling it or by taking a debt.
But what would be wrong with reading this, that that's the presumption, and it would be up to the defendant to come in and say, you know, Judge Fahey, I've tried, I can't do it. I just had a bankruptcy, I have no ability to get a mortgage loan on this property.
And it's small and there's
Yeah.
no, I understand that. That would be part of the process. I mean, the way the rule is set up is you go over this determination of indigency a few times before you actually have someone who's pointed to.
But you seem to be arguing that sort of as a matter of law, property isn't liquid enough to be counted.
Well, I don't think that the property. I think it can be counted. I mean, you're not going to ignore on a balance sheet the fact that somebody owns property with no mortgage, or you want to take into account how much equity they have in an asset. I'm not saying that you don't do that, but I'm saying that, well, as a matter of law, property, real estate is not readily liquidatable. It doesn't.
But you can get a mortgage. You can get one of those equity lines of credit.
You certainly can, but in this case, she just gone through bankruptcy. Her, there's real question about the valuation of the property.
It's got no mortgage. It's worth something.
It would likely be worth something, yes. But again, until you have cash in hand, you're bargaining.
So there's no obligation on the part of the defendant to show that I've gone to 3 banks and made an application for an equity line of credit and for $10,000, and it was denied in each case.
No. I do think that becomes part of the process when you're determining someone's indigency status for absolutely. But again, as I read the statute, as I read in the last part of the last argument, it's the probation office that's responsible for making sure that this person is indigent. And it's their burden, but there's no question that if you have property and real estate, you need to show that you're making at least an effort to sell it or to get another mortgage on it. But if you can't, then that also becomes part of the determination. In other words, what I'm saying is, it takes time to sell real estate, is all I'm saying. It takes time to take out a mortgage on real estate. And when we're talking about getting someone, when we're talking about getting money fast to hire an attorney so that you can then begin the process of going through trial, because trial is not just, the day you call a jury, but you have to go through, everything that happens pre-trial. I mean, you need an attorney almost immediately after you've been indicted. And so what we're talking about is how fast can you get access to those funds, if you can get access to them.
But here, do you agree that the income for the husband and wife was over $60,000 a year, and that they owned 3 pieces of property, one of which was valued at almost $300,000, no mortgage or anything on it? You agree to that as our basic facts?
Those were found as facts.
Yes. Sir, I'm sorry, but your time is up.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Daniel Sullivan. I appear on behalf of the intervener, Administrative Officer of the Trial Court, in my role as a Special Assistant Attorney General. Your Honors, all defendants have a right to counsel, but the right to publicly funded counsel only attaches when the defendant proves herself indigent. I urge you to affirm Judge Fahey's determination that Mrs. Porter is indigent in this case.
Is not indigent.
Let's play it out a little bit. I mean, are you saying
Not
that
indigent.
are you saying
Thank
that she is not indigent because of her income or because of the equity in the properties?
The judge looked at both. She said, at one point, she said, you don't get to have, $60,000 plus in income and to own 3 properties and to claim a publicly funded lawyer.
Okay, so is the view then that she should stop paying the mortgage on one of them and use that money for counsel?
Well, on the Plymouth property, Mrs. Porter alleged that the property had no value, that the mortgage is exceeded, which isn't accurate. The mortgage was about $123,000. The property had been appraised at $190,000, so there was some value in that property. She had said that she couldn't sell the property, and the point there, as Judge Fahey remarked, it's sometimes difficult to move a piece of property, but if you price it right, it'll sell. In other words, I don't think the defendant has the option of saying, well, I'm not going to sell that property because I couldn't get a good price for it.
Well, let's assume the person's acting entirely in good faith and say, I'm going to try to sell the property. I'm going to try to sell it at a fair price. Could take months to sell a property. What's to happen in the interim?
I would think that the better course would be to pursue a mortgage, and I think
But that may be difficult depending on, I guess the valuation here was in 2006, and that property may be substantially reduced in value, and because of the bankruptcy, it may be hard to get.
Right, and I don't think the judge considered really so much the value of the property in Plymouth or in Tewksbury. The judge really looked at the value of the Revere property, which Mrs. Porter alleged was owned by her husband. And there we come to the Rule 310 requires the spouse, treats the spouse's assets as available to the defendant. And I see that as really a policy choice that was made by the drafters of the rule, that because of the way most marriages operate, we're going to have a presumption that the spouse will contribute. But if the spouse will not contribute, then the defendant is free to come forward and demonstrate that.
Okay, so it is a presumption. Rebuttable, but a
A
presumption.
rebuttable presumption, right. So, and then...
So you agree that it is conceivable for the husband to say, that was the property that my parents owned, it's been in the family for 3 generations, I'm not going to be the one to sell it. It's not available for sale.
Right, they could certainly, again, seek a mortgage. Some of the evidence that I saw in the record suggested that this property may have been put in the husband's name as a result of the prior bankruptcy. And it brings me to the point that a rule that would allow that, it seems to me, would encourage defendants, if we speak of a career criminal, to make sure that no assets were in his name so that he could get free counsel without having his spouse's assets reached. I think that rule wouldn't be workable. Judge Fahey properly placed the burden on the defendant to demonstrate her indigency. There's extensive case law, both state and federal, that supports that proposition. I think one important point, which the federal courts actually make quite emphatically, is the importance of conducting an appropriate inquiry. And I think this case is, if anything, a good example of how thorough a judge needs to be. The Judge Fahey held 3 hearings on the indigency of the defendant, and she obviously based on her questions, had reviewed extensive materials that had been submitted both by the Attorney General's office and by the defendant to show her and Mrs. Porter, by the way, did produce evidence of her financial condition. The problem was that the evidence of her financial condition did not show her to be indigent.
But I guess one concern I have is the time lag. I mean, let's assume you're correct about everything. And let's assume the person is making good faith efforts to obtain a loan and is having some difficulty. What's to happen in the interim? Is the case to sit for 2, 3, 4 months while the matter is resolved and a closing occurs?
I would think that ordinarily counsel could deal with the defendant on that and say, okay, well, I want to put a lien on your property, and at the time you get a mortgage and you pay me, I'll remove the lien. It seems to me that there are ways to work around that. I don't think that would justify someone owning very valuable property and saying, well, I can't sell it, I can't mortgage it. It's not, because there's a tendency in that case to say it's not convenient, or I won't make a good profit on it.
That's a different question. There's a different question as to whether they ultimately say, I can't, I tried and I can't. I'm referring to a situation when they say, I think I can. But it may take a substantial period of time for the money to show up, because it certainly takes time to sell a house and to close on it. And it takes some time to have the appraisal done and get a second mortgage or a line of credit. What's to happen during that period of time? The person has been declared not indigent, therefore there's no access to counsel. Is the case supposed to just sit and wait?
I see that as problematic. Obviously, this case has been stayed pending this appeal. I would think that a judge would have to look very closely at the evidence presented that a mortgage couldn't be obtained in any reasonable period of time. If I were the judge, I would also question counsel. As to counsel, can't you make some arrangement with this defendant? You know she has a valuable piece of property. Isn't it worth your while to make some arrangement with her that you'll recover your fee once she's able to mortgage that property or to sell that property? I think the court should make every effort to encourage counsel and the party to find a way to move forward.
Who's the counsel in that situation that you're urging to do something? I mean, is there a lawyer there?
Well, you have a good point, Your Honor. At that point, the defendant's trying to find counsel.
Well, yeah, but you're not going to bring somebody that you haven't. How are you going to get them in the courtroom to talk to the judge?
Right. But that's it. I would think there's a burden, I should say, on the defendant to make an effort. Really, I think the defendant can't stand by and say, "Well, gee, I can't mortgage my property."
No, but Judge Gantz is asking. Somebody is making an effort, but it takes time. What's supposed to happen to the criminal case?
Then I think the burden is on the defendant to approach a lawyer and to say, "Look, I'd like you to represent me. I don't have ready cash."
Suppose they do all those things and it just doesn't happen. I mean, what's supposed to happen to the criminal case?
Well, short of staying the case, I think we want to do everything to avoid requiring the party to go forward without counsel. But at the same time, I mean, if the case needed to, I wouldn't say even stayed, I would say continued. It seems to me that, and Judge Fahey, by the way, told this defendant repeatedly that she would give her additional time, if necessary, to develop evidence of her indigency. But I think in that case, if the case had to be continued for some period of time, obtaining a mortgage, it might take a month. I don't think it takes 6 months. And if you can't obtain a mortgage, then it seems to me you've got to speak to counsel and see if you can find someone who will accept a reasonable arrangement so that they can ultimately be paid for their fees.
And what if she's in custody?
Well, the standard on indigency is affected by that.
I understand that, but the consequence of a delay is, I mean, if the person is basically being held because the person can't make bail, then the person sits. And under your view, the person sits, and of course the person is not ideally situated to be selling property if they're in custody. So how is that to work?
Well, although in the case of the individual in custody, I think they would be, if they had no available funds, they would be determined under the rule to be indigent.
Not if they had all sorts of property.
I
mean, would the situation be different if she were in custody here?
It would. That does affect the outcome.
Why would it? if she still has the same property, the same access to money, she just happens herself to be in custody, why would that affect
In rule, this is Rule 1F, Rule 1F 4 and 5. A party who is serving a sentence in a correctional institution and has no available funds, or held in custody and has no available funds.
So we go back to available funds, which means we go back to liquid assets, which means we go back to a determination as to whether or not the real estate, equity in the real estate is reasonably convertible to cash.
Reasonably convertible, and I would stress
And
that.
that's the defendant's burden to show that it's not reasonably convertible to cash, I assume.
That's right. I believe that's true. Again, it's.
Well, can a judge appoint a lawyer and order the defendant to make a contribution, in this case, of $5,000 to be paid to the Commonwealth?
What the judge said here in a footnote was that if the defendant was unable to get counsel for $5,000, she could return to the court. And the judge at that point would consider whether or not she could be treated as indigent but able to contribute.
Which is $150 a month, isn't it? Isn't that what it is under the rule?
The judge can require a contribution, determine what the amount of the contribution should be. That would be over and above the $150 counsel fee.
So a judge could order something more than $150 a month?
Yes, if they're indigent but able to contribute, the judge orders something in addition to the $150 a month.
So a judge, in your view, could say, well, she's temporarily indigent, and therefore I will appoint counsel, but I expect that she will soon not be, and therefore I'm going to order that immediately upon the funds being obtained, that those funds will be used to pay counsel, and at that point she will no longer be indigent.
There is an ongoing responsibility on probation to avail the judge of any information they have that indicates a change in circumstances, that would indicate that the person had changed from indigent to indigent but able to contribute.
Counsel, your time is up. Thank you.
Thank you, Your Honors.